Good morning and welcome to our presentation, From Trust to Taxes, Customizing Your Estate Plan. My name is Ben Burton. I'm a tax shareholder here at Lutz. Also presenting today is Tom Hodgson, one of our investment advisors with Lutz Financial. So just a quick refresher on Lutz. We were founded in 1980. We have 3 offices in Nebraska with 375 employees. The Lutz value proposition is leveraging our Lutz network, striving to be an advisory partner versus only doing your compliance, and we are technology driven.
And on the Lutz Financial side, we do help clients with financial planning, investment advisory, as well as retirement plan services. As of December of this past year, we were at 2.6 billion in assets under management, and we do have around 600 or more households that we work with.
On the agenda today, estate plan customization options, trust-based asset protection, techniques for minimizing estate tax liabilities, action steps for updating your estate plan.
I will lead us off here with some of the estate plan customization options. And I think one additional note that's probably worth mentioning is this presentation is going to be a little bit more foundational based, probably more on that intermediate level. We did last year do a more advanced presentation as well. So if you have questions, certainly feel free to send them to us afterwards. And we can send you that as well. So I think the first place that we wanted to start was, why do you need an estate plan? So I think when we kind of look at that, we always tell everyone, you have an estate plan, whether you know it or not. If you haven't done one yourself, generally the state that you live in has one for you. So I think this is a good starting point with the Nebraska intestate laws. And that just means what happens if you die without a will. And so again, some of this, you will have access to these slides afterwards, so we won't read through every single one. But I do want to highlight a few examples here. If you are married and all of your children are with your current spouse, if you pass away without a will or a trust or any of those documents, your spouse gets $100,000 plus half of the remaining balance of assets that don't have a beneficiary designation title there. The children split the remaining half of those assets. So again, there may be some unintended consequences if you don't do some proper estate planning up front. And again, there's obviously all sorts of variations. Everyone's situation is going to be different. That's just kind of the nature of how we all are, our family dynamic. But I think it's just important to know that doing nothing does also have consequences. So starting off from the kind of the start here, what's the difference between wills and trusts? I think people hear about this a lot. I know a common misconception that we hear on our side is that, well, I don't have enough assets to need a trust. I just need a will or a basic, tool for that. That might be right, but it may not be. And again, I think trusts are a lot more common than are sometimes expected. So wills are really kind of the first bucket that people go to, and that will designate your personal representatives. Again, if you have children that are minors, that's generally where you're going to be listing who you want to take care of them. And it's kind of a backup plan for any of your assets that is not currently titled or needs to be cleaned up. So again, if you have a life insurance policy or a retirement account, if there's a beneficiary, that will go based off the titling, not based off the will. But let's say that you have a vehicle that doesn't have a transfer on death designation, your will would then be the tool that kind of decides where those assets go.
Yeah, and Tom, we'll talk a little more about this later, but we like to think about wills and trusts as being a document you update on a regular basis. So it's not just, hey, we're going to set our will today, mid 2025, and that's going to be the way things have to be from here on out. For my wife and I, we've got 4 small kids, and so we set a designated guardian for our children today. That might change 5 years from now. So these are living, breathing documents. Make the best determination today on who should be the guardian, who should be the trustee, who should be the medical power of attorney. But then down the road, as life happens, these can be updated.
I think that's a great point. That also applies to trust as well. So when you think about trust, generally that's how you want assets to flow upon your passing. So again, a trust can hold legal title during your lifetime. It can also help you avoid probate if structured properly. There's also an added layer of privacy, and then you can get a little bit more prescriptive control about how those assets will flow upon your passing. And again, we'll talk about these a little bit here, but the ages of distributions for beneficiaries, Ben mentioned this. I'm in kind of the same area. We both have minor kids. We may not necessarily want them to get these assets right when they're the age of majority. A trust can help you establish when you want them to get it. So again, I think we look at this, there's very common trust types. Testamentary and revocable are probably the two most common that we see for again, kind of that more intermediate group. The irrevocable trust, again, it's common, but it's generally kind of catered for people that are trying to do more, minimizing estate taxes or shifting assets outside of their taxable estate. But we'll kind of touch on that a little bit. The testamentary trust, you can just have that be created in your will. So that would say, again, it doesn't exist yet, but upon your passing, that opens up, and that can have provisions for how assets flow to your kids, at what ages you think they're old enough, mature enough to receive those. With a testamentary trust, you cannot list assets today in them, but they can be the beneficiary on account types. A revocable trust, also known as a living trust, they are established today. Generally, while you're alive, they do just take your social security number as the tax ID number. They could be a separate tax ID number, but generally that's what we see. And you can list assets and move assets into those today. So again, your home is an example of people commonly own. Your trust could be the owner of that, and that would then designate how you want that to be utilized or flow upon your passing. The irrevocable trust can also be established today. They can be gifted assets today. Generally, once you gift assets into an irrevocable trust, you're kind of giving up a lot of the control that you have. And that's one of the limitations about the irrevocable trust. Where revocable trust, that we just mentioned, life is going to evolve and change. You can update that document as you go forward, as your life changes as well.
Yeah, so think revocable, I can change it. Irrevocable, it's a more permanent structure.
And kind of again on these foundational documents, additional things that we think everyone should be considering. Powers of attorney is another big one. Again, financial power of attorney, medical power of attorney are two of the big ones that you think about. What happens if you become incapacitated? Who do you want to be making the financial decisions? Who do you want to be making the medical decisions? They may be the same person, they may not be. Again, we hear clients all the time say, well, I've got one son or daughter that's an adult that we think is, someone that can help us with the financial side. You may have one son or daughter or family member that's in the medical profession. So it may make sense to split those, but that's something that you want to evaluate. You can also have an advanced directive or living will. This is different from the will on the previous one. This more so is a written statement that says, what do you want to have happen to you if you're incapacitated, if doctors have gone through it and they've determined that, again, there's not any way to bring someone back. This would give your kind of your last will and intentions. The beneficiary designations, again, I think this is a critical piece that we always discuss with clients as well. The coordination of your estate plan with your beneficiary designations is a critical piece. You can have the best estate plan in the world, but if you don't update your beneficiary designations, that is actually the first place that it's going to go to determine the flow of assets. So again, anytime that you're updating your estate plan, it's also crucial to update beneficiaries to make sure they're coordinated. And then the guardianship, we talked about that briefly as well, but who's going to take care of the minor independents? One additional consideration here that you can kind of think about with a financial trustee as well. If you're gone and someone's taking care of your kids, sometimes we see that there may be benefit to having the guardian and the financial trustee be different people. You're kind of also, again, allowing the person that was chosen to be the guardian really do what's best for your kids and not worry about the finances, not have that conflict. It also helps remove the guardian from being kind of the person that's in between your kids and their assets. And they think, oh, well, that person taking care of me doesn't care about me. They're worried about the assets. So there's some power in that as well, but something that I think everyone should take into consideration when they're updating their estate plan. And really, I think the benefits for this kind of initial piece, why do we want people to customize it? everyone's family is unique. Everyone has a different dynamic in terms of marriage, divorce, kids, no kids. Blended families are very common. We also see clients that have children with special needs, and they may want to protect, benefits or access to benefits that otherwise assets could, potentially unintentionally, remove them from. And also people have complex assets as well. Maybe there's a family farm. Maybe you have certain assets that you want to go to somebody. Again, we work with a lot of business owners, and they may have some children in the business and some not. You may want to handle that differently because you may not want your children in the business or that are going to take over the farm be forced to sell it to, again, provide that value to the non participating members. But I think the big thing is that way you can accomplish what you want, and you're kind of doing it proactively versus it being a reactionary thing. Upon someone's passing, it's a very emotional time as it is anyways. But if you've had these thoughts and you kind of direct where you want things to go, it does make it a little bit easier on your family to kind of, again, help your intentions be followed.
Okay, thanks, Tom. I'm gonna talk a little bit here about trust-based asset protection. So, these are all different provisions that you can have inside the trust, or different trust documents you can have. So Tom talked a little bit about the revocable living trusts. So those are the trusts that he talked about where you're typically using your social security number as the tax ID number, mainly to avoid probate, have more privacy and control. When Tom was talking about those Nebraska intestate laws at the beginning, if you pass away without assets inside a living trust, you have to list out your assets in a court document versus just saying, my living trust. So that's giving you a little more privacy than the alternative. So any trust document, you're going to have dispositive provisions in, which is clauses on how and to whom the trust assets are distributed. Those will typically state ages that the beneficiaries would receive the funds, as well as specific uses for the funds while the assets are held inside the trust. So, if you think about minor children who are beneficiaries of a trust, oftentimes there's clauses that the funds can be used for health, education, maintenance, and support while they're, younger. And then maybe there's, whoever creates the trust, you guys will have to determine what age you want them to receive the funds outright. But, maybe it's at age 30 or 35, they're going to get a third. 5 years later, half of the remaining, and 5 years later, the full amount that's left in the trust. So that's the dispositive provisions, just say, how and whom the trust assets go to. We mentioned the irrevocable trusts earlier, so those can't be changed, or very limited ability to change those irrevocable trusts, but those do provide asset protection from creditors as well as asset protection during divorce proceedings. So, if you're trying to establish some of those protections, you might need to be looking at the irrevocable trusts. Special need trusts. So there's certain government, eligibility or government benefits that your special needs dependent might qualify for, but if they have too many assets, they'll no longer qualify for those programs. There are special needs trusts that can be structured to where they can get the benefit of the trust while still maintaining the benefit of the government programs. The spendthrift provisions kind of tie into those dispositive provisions, but limits the distributions to the specific intentions and also prevents reckless spending. That way you don't have somebody that's 25 getting, $1 million trust when they're probably gonna spend it on frivolous items. You have a trustee in place that's going to say, hey, we're gonna allow for, there's a 5 and 5 power, maybe it's 5% of the assets of the trust could come out every year. And that way, the majority of the assets can be invested and maintained inside the trust, to prevent that, irrational spending child from having too much access to the funds.
And I think one other important component here is that a revocable trust is something that you set up while you're alive. Upon your passing or upon you and your spouse's passing, your revocable trust becomes irrevocable at that point. So your kids now can step into that role. And again, depending on how it's structured, it may flow assets out to them and then no longer exist. We are seeing more and more common that, again, these trusts are set up where your child may become the trustee of their own trust so that they have access to use the funds if needed, but they're not being forced to pull it out. So again, one question that we see, and part of this is just with, again, that divorce protection. If I was somebody that was going through a divorce and I was given assets where they were pushed out into my estate and I moved them into a joint account, and then I subsequently went through a divorce, those assets could potentially be subject to that divorce proceeding, where if they were held inside an irrevocable trust, that is a protection as well. So I think that's one thing that we are seeing become more and more common. Now, there's an additional layer of complexity there. They do require their own tax return. They do have some additional, again, restrictions intentionally. So you have to determine whether or not it's worth it, depending on the size of the trust. That sometimes can be the deciding factor of whether to keep assets in trust for your kids or beneficiaries or have it be distributed outright to them.
Another thing I want to mention up front is that these trusts, we're well versed in them, but we're not attorneys and we can't create these trusts for you. So we work with a lot of law firms around town. We sit in on meetings with clients and their attorneys very frequently. So happy to help facilitate the discussions, but Lutz is not a law firm and we don't create trusts. So want to make sure everybody knows you've got to have your own attorney to create these documents. So some additional types of trusts. So the family trust, marital trust, Q-tip trust setup. So, when the federal estate exemption was lower than it is today, right, for 2024, I think it's just under $14 million. But oftentimes, 20 years ago when it was $1 million, you'd say, okay, we'll have $1 million go into the family trust. That's outside of mom's estate. There won't be any estate tax on that amount. And then the remainder will go into a marital trust that's for the benefit of mom while mom's still living, or surviving spouse. So this just kind of you'll hear an A-B trust setup, family trust, marital trust setup. And it's really just to give asset protection for the benefit of the surviving spouse, while they're still living. And then after that, those trusts will have the dispositive provisions in them on, whom the assets should go to and at what point they'd be paid out.
Yeah, and then the other point up there, Nebraska elective share. This is something that, some states do. Nebraska is one of them. If you, again, if you were widowed or if you were divorced, and then later on you go through a second marriage and you maybe have intentions with those original assets before the second marriage of going to kids from the first marriage, with this, you just want to make sure that you're aware of the Nebraska elective share, because you may want to do some trust planning ahead of time to ensure that, again, whoever the intended beneficiaries were receive those assets and they don't end up getting divided, again, against what your original intentions were.
So the next type is generation skipping transfer trusts. So I think most people are familiar with estate tax. So that's, okay, when I pass away, if my assets are in excess of the federal exemption amount, they're subject to estate tax. Generation skipping transfer tax is a second layer of tax that applies that if I want those assets, instead of going to my kids, to go down to my grandkids, now there's a, second generation. Government doesn't necessarily like that skipping ability. And so they created this generation skipping transfer tax. So right now, the GST exemption amount is tied to the regular estate tax amount. So they're both at that $14 million threshold. And so you can structure a trust to use all of your GST exemption. And that way, if future generations are pulling out assets, it's not subject to this additional layer of tax. Whereas if you didn't have the GST exemption in play on your trust, future generations potentially would need to pay GST tax when they pull those assets out. This would be, if you're, some people call these dynasty trusts, where it's not just, hey, I've got enough assets that I'm gonna push down to my kids. It'd be, okay, I've got enough assets that I think I want, 3 or 4 generations of Burtons to be getting the ability to have assets inside of a trust. That's a pretty complex scenario, but that's something that's available. There's also Medicaid asset protection trusts. So this is similar to, you want to maintain assets, but also have the government benefits. And so for Medicaid planning, you've got a 5-year look back. And so if you've got a parent who potentially will need to be in a assisted living, or some type of memory care, or long-term care facility, you can potentially fund one of these protection trusts such that rather than their life savings going towards the long-term care, their life savings can go to their beneficiaries, and Medicaid can take care of the long-term care piece.
Yeah, and then one additional note is with long-term care insurance, there is rules for asset protection. So if I have a long-term care policy, it's a traditional policy, and I have $500,000 of benefit pool, I get to protect an additional $500,000 of my estate that can go to my beneficiaries that I don't have to spend down before I can qualify. I would say long-term care is an area that's constantly evolving and changing. As of right now, it's only traditional long-term care policies that fall into this rule. I know there's some potential legislation changes that may allow asset-based policies to have that protection. I think the big thing, or the big takeaway on that piece, is if you have questions about this, ask your professional, ask your state attorney, ask your CPA or financial advisor. They'll be able to help explain, what those protections are and what makes the most sense for your specific situation. Now we're going to shift gears a little bit and talk about techniques for minimizing estate tax liabilities. I think the starting point here is looking at what the estate tax exemption is currently. So Ben mentioned this, but as of 2025, it is 13.99 million per person that you get to pass down to the next generation or anybody and not have to pay estate taxes. The reason why we show this graphic is it really wasn't that long ago, 20 to 25 years ago, that it was $1 million per person. And that definitely brought a lot more clients into that realm. This is obviously one that's under the kind of gun right now in terms of, will it get extended? Will it not? There is some legislation that's, being promoted right now that would extend it. But again, until anything is finalized, we never want to try to forecast politics and what's going to happen on that side. We just want to understand the rules and then work within them. I do think one other important distinction, if you have an estate tax problem, let's say that you made a gift in 2020 and you fully use your exemption amount, there has been an inflationary component to that every year. So if you look at it today versus 2020, you may still be able to give an additional about $2.5 million to your estate or irrevocable trust and capture some of that. So this is one that's worth monitoring. And I know Ben's gonna talk about the timing of that a little bit.
Yeah, so there was a bill released by the Ways and Means Committee on Tuesday, either Monday or Tuesday. And that's not a law. There's been other tax bills that have been floated out over the previous handful of years where they passed the House, but they wouldn't go anywhere in the Senate, or they'd come out of the committee, but they wouldn't be passed by the House. But the bill that the committee released just kind of gave kind of the skeleton provisions on, you know, what they plan on trying to extend of the current tax law, which included, you know, a permanent extension of this state limit set at 15 million, tied to inflation. So, you know, there's been discussions as far as timing on what the current administration would like for when this bill would be passed. You know, there's been different timelines floated as far as, is it Memorial Day? Is it July 4th? If you look at back in 2017 when they passed the last big tax law changes, you know, that came out roughly 10 days before December 31st. So there is some, you know, legislation going on in 2025. These provisions do sunset if there is no action taken by Congress. So one of those things that we're definitely keeping our thumb on as far as where's stuff at in the process. But, you know, for anybody that's looking at their estate here over the next, you know, 6 to 8 months, you know, you want to make sure if you're close to these levels that you're getting something in place, so you don't miss out on the additional exclusion amount. With the sunset would take it from the current 14 million back to the 2017 levels, which those adjusted for inflation would probably be in that 7 million range. So if no action, down to 7. There's pending legislation, it could be 15, but as of today, we know it's gonna be, you know, 13.99 million for the remainder of 2025. So the Nebraska inheritance tax, so Nebraska doesn't have an estate tax. So estate tax is when I die, what are my assets worth, and if they're above an exemption amount, there's going to be tax due on that. Nebraska doesn't have an estate tax system. Nebraska does have an inheritance tax system, which is, okay, here's all my assets, here's the who's inheriting all of those assets, and depending on the relationship to the deceased, here's the amount of tax that each one of those beneficiaries is going to receive. And so this is something we just want to make sure people are aware of. This is a court filing done by an attorney. So Lutz doesn't do these, but just an awareness piece of it. So if I pass away, anything that goes to my spouse or charity, there's no inheritance tax. Assets over 100,000 that go to, you know, what I call lineal descendants, or my household relatives, so parents, grandparents, siblings, children, that's subject to 1% in excess of 100,000. So a fairly, you know, nominal tax. Once you get further outside of that, it jumps all the way up to 11%. So pretty significant jump going from that, you know, household relationship out to uncles, aunts, nieces, nephews. And the threshold for that is only $40,000. So much higher rate, much lower threshold. And then anyone else, so, you know, someone totally unrelated, would be subject to 15% at 25,000. And they do pull back gifts that are made in the 3 years before death. So there's a lot of, I shouldn't say there's a lot of planning to be done around it, but you know, if you're someone that's thinking about getting assets to an unrelated party, probably better to do that before you pass away, rather than wait until post-death. So more of an awareness, but there is some planning that you can do around that.
And one additional piece on this, and actually Ben and I are both on the Omaha State Planning Council, and we just had a speaker come and talk about this as well. If you think about, let's say somebody that, again, maybe their previous spouse predeceased them, and now they are living with a new partner, but they've never gotten married. Again, you can leave them assets, but if you are not married, they would fall under that kind of fourth tier there of the 15% value. So some of that needs to be thought of ahead of time, and you know what you can do to structure it. But again, there are some potential unintended consequences that if you are reactionary and don't do anything, that you could end up paying or have them paying more in taxes than what was originally intended. So some additional tax considerations, obviously what we were talking about up to this point was the estate taxes and inheritance taxes. But we know a question that we frequently get is income taxes, and you know, what are the implications on this side of it? Again, I think one thing that's worth mentioning is that there's always been discussions of, you know, legislation changes over time. As it currently stands, your spouse, if you are married and you pass assets back and forth between your spouse upon your passing, you know, those get to generally continue on as if nothing happened. So if I have a retirement account and I pass away, my spouse can now claim that as their own. There are some other options, but they can claim it as their own. So there's no additional tax consequences or no additional accelerated distributions. If I own a property outright and I pass to my spouse, one benefit is that it would potentially get a step up in cost basis. And so what that means is if I bought a piece of farm for $1,000 an acre and it's now worth $10,000 an acre, if it was titled only in my name, it would pass over to my spouse and get a full step up in cost basis. If they turned around and immediately sold that, they would pay no capital gains taxes. Where if we owned that asset jointly, it gets a 50% step up in cost basis. So then my spouse may, in that example, potentially consider retaining that asset until they're passing to get the full step up in cost basis. So that would be how it works for a spouse. For a non-spouse, there are some additional rules. Here it gets a little bit tricky because there's also rules. There was rule changes in 2020 with the Secure Act and how assets are inherited by beneficiaries that are not your spouse. Previous to 2020, you could stretch those distributions from a retirement account over your lifetime. Now, if someone passes after 2020 and it goes to a non-spouse, so again, think of that as like kids, grandkids, any of that kind of next generation, they have 10 years to fully distribute that bucket of assets and pay up taxes. So for that example, if I had a $1 million IRA and that went to, and I only have one child that goes to one child, they would have to pull out, in theory, approximately $100,000 per year for each of those 10 years. That's drastically different than it was previously. So there are some tax implications that aren't necessarily directly, but that my beneficiaries would have. Now, again, with some of those rules, they can delay it. So, you know, one thing that we see commonly with clients, mom and dad pass and leave it to their kids. Their kids are in their 50s or 60s. They might be required to take a small portion annually, but they can push that or delay that until, you know, year 10 if they wanted. That may make sense if, let's say, someone knew they were going to retire in 6 years. They may only take the minimal amount for the first, again, 6 years, and then really accelerate it after that once they're no longer in a higher tax bracket. So there are some tax strategies that come into play, especially with retirement accounts. But that's something that we want to, again, work through and ultimately maximize the dollars for you and your beneficiaries versus having it go and pay taxes. Trust accounts can be listed as beneficiaries on retirement accounts. They do follow the 10-year rule. These can get a lot more complex. So again, I'd say you probably defer to your CPA, your financial advisor in terms of how that would need to flow, but trust would work a little bit differently as well. And then now for a non-spouse under current legislation, any taxable accounts or any taxable assets. So again, that could be your primary house, it could be vacation home, it could be farm or real estate, or your investment brokerage account. All of those assets would get a step up in cost basis. So the next generation could, in theory, sell it the next day. And as long as there wasn't appreciation or depreciation between the date of death and the day they sell it, they would not pay capital gains tax on that piece. And obviously, we put that caveat on the bottom, but consult your professionals for guidance on how to structure these beneficiary designations. Again, a lot of the attorneys that we work with, they do a really good job of summarizing it at the end and give you a kind of a cheat sheet of saying this account should have, A listed as primary beneficiary, B listed as contingent, or some variation of that. So again, you can be very prescriptive on how you want assets to flow, but the biggest, I'd say, piece of advice that we'd want to tell you is be coordinated, because again, lacking some of that coordination can have unintended consequences.
So another point on IRA as well as other retirement accounts. So those assets do not receive a basis step up. So when your beneficiaries are taking money out of those IRAs after you pass away, those are fully taxable if they're traditional IRAs. So with regards to someone who's thinking about doing some charitable giving on their passing, we highly strongly recommend donating IRAs or pre-tax accounts to charities if you've got other assets that will receive a basis step up, so that your beneficiaries aren't paying tax on the IRA accounts and the charities receiving an asset that has a basis step up where you wouldn't even have tax on that if the beneficiaries, the non-charitable beneficiaries, had received it. And then also on transfers between spouses, I believe, if let's say one of the spouses receives a terminal illness, I think they have to have title to those assets for at least 12 months for the basis step up to occur. Otherwise, they look at what how the assets were titled 12 months before death, as far as receives the basis step up. So, I know with a lot of our clients, well, I shouldn't say a lot of our clients, I should say with the longevity, for most adults, females are going to outlive males. And so, do we push more buckets into one spouse's name versus the other? Then you're kind of playing the game of, well, what if the other one receives the terminal designation? So, 50-50 makes sense in a lot of instances, but you might have something in your personal situation where it makes more sense to have one spouse with more ownership than the other.
So thinking about some other estate reduction items. So again, this can apply across the board, whether you have an estate tax or not, but how you can maximize dollars for, again, your intentions and your beneficiaries. So the first thing we always say, one of the fastest ways you can reduce your estate is spend it. And that may be taking your family on a trip. That might be, again, going out and doing something that like that dream vacation you've always wanted to do, that bucket list. You can give it. So again, the annual gift limit for 2025 is $19,000 per person. So if you're married, you can give $38,000 per person. If your son or daughter is married, you can give to their spouse as well. So again, it's very powerful. You can give away a lot of dollars, and those gifts do not require an additional tax return. And they also don't take away any of your current exemption amount. So again, if we do see any legislation changes and the exemption amount comes down, this is something that you can do to, again, help reduce your taxable estate and minimize taxes. You can fund college accounts for your kids and grandkids. That can be a powerful way to give assets but still retain control. I know a question that we get a lot of times is, what's the best way to give to kids or grandkids where, again, they don't have immediate access because maybe they're not ready to handle it, but you still get some of the benefits on that side of it. And then another one that does not go against even the annual gift limit. If you pay directly for any sort of tuition expenses, education expenses, or medical expenses, that does not count against that annual exclusion limit. So really, again, that can add up very fast as well. The next one is donate it. And again, thinking about what you're passionate about, how you want assets to flow, this can be a very powerful one where, again, Ben mentioned this very in depth, but you can specify the best asset inside of your estate to give to charitable causes or things like that. And again, there's tax benefits of doing this not only while you're alive, but also upon your passing. We listed on here a donor advised fund. This is a fund that you can give assets to while you're alive. And for example, if you have highly appreciated stock or securities, you can give that asset. You don't have to pay the capital gains on what the appreciation was, but now you get to give that out to the charities of choice. Again, a lot of charities will actually receive stock in kind as well. So we see that for a lot of clients, help a lot of clients do that. Once you hit the age of 70 and a half, you can start to give directly from your IRAs to charitables. It's called a qualified charitable distribution. Right now it's $108,000 per person. Now, granted, you have to have an IRA to do that, but that's a powerful tool. And then the one additional piece that I think can be powerful is you cannot give directly from your IRA to a donor advised fund while you're alive, but you can list your donor advised fund as the beneficiary on your IRA, or you can carve off a separate IRA. Again, let's say that I wanted to leave $100,000 upon my passing to a school that I went to a church that I'm a member of. I can list either that church as a beneficiary, or I can list my donor advised fund as the beneficiary, and then you can pass that into that bucket and continue to give it out. We see this with clients too that are very philanthropic and they want to pass on kind of the spirit of gifting to their kids or grandkids. You can list your kids or grandkids as the successor owners of those donor advised fund. So you can kind of really instill that charitable intention to them, because those funds are irrevocably given away. So your kids or grandkids can't use them for their own benefit, but now they can think about what's important to them and they can decide where to give those assets to. The last one, prepare for it. So again, I think just coordinating your overall estate plan. Life insurance is a big one. If you have life insurance inside of your taxable estate, that will be additive to your estate value. Now, if you're under the 14 million per person limit, not a big deal. But if you are above that $14 million taxable estate limit and you have life insurance come into your taxable estate, that could potentially push you over. So in that case, it would cause estate taxes by being structured inside your taxable estate. So there's methods of doing it. We'll talk about it a little bit on the next page, but you can give a life insurance policy into an irrevocable trust, and now that death benefit will be outside of your taxable estate. There's a calculation that decides the value when you give that asset, what it's worth. So you may need to use some of your exemption to do that, but then the death benefit is tax-free and outside of your taxable estate. So that's one that, again, probably requires a little bit more additional planning versus, again, doing nothing and letting it be something that's solved later on. The last one is you can convert IRA dollars to Roth during your lifetime. So we just talked about this. IRA assets do not get supplemental basis, and they're going to be taxable at some point, whether it's to you or whether it's to your beneficiaries. And especially now with that rule being, minimized down to 10 years, that could definitely have some material impact to your beneficiaries and their tax bracket. Maybe right now you're in a lower tax bracket than your children are because you're retired and you don't have that income coming in. Maybe your son or daughter is a very successful professional or medical professional, and they're in the top tax rate. If they inherit that asset, that IRA, and they have to pull dollars out, they may be paying more in taxes than you would be. So this can be a tool to help minimize taxes on the dollars inside the IRA, and it also can be a tool to minimize your taxable estate. The last piece here that we have for the trust planning is just a few examples of some of the ones that we see more often for the irrevocable trust type. Now, we did go a little bit more in depth on this on the advanced seminar that we did. If you have questions about this, please let us know offline, and we can help kind of address some of these questions as well. But these are some of the more commonly used irrevocable trusts that we see people use during their lifetime that can help with that estate tax issue. Again, if you're over the $14 million taxable estate, or 28 as a married couple. So these are some items to think about that you can use and capture appreciation outside of your estate. And it's kind of jumping ahead. You can capture the appreciation outside of your estate. So that's another thing to kind of think about and forecast. And again, why we'd say you want to plan ahead. You may not have an estate tax problem today, but if your assets are growing faster than that inflationary increase on the estate rule, you could have an estate tax problem in the future. Well, if you gifted an asset today into an irrevocable trust, that growth that occurs is outside of your taxable estate. Now, there's give and take on that side of it. Gifted assets into an irrevocable trust may potentially lose their step-up cost basis. Again, there's ways to structure it to give you a little bit of flexibility, but I say we're probably getting back more into that advanced seminar. So if you have questions on this side of it, please reach out to us and let us know. We're going to take a second to pause here. If anyone is on for CPE credit, please answer this question and you'll receive CPE credit.
Okay, so as far as, kind of, we've talked through a number of things, but what are some action steps for updating your own estate plan? So we talked about this earlier, but reviewing your estate plan every 3 to 5 years or after life events. I mean, it's a living, breathing document. Life events of such as marriage or divorce, children, retirement, children both on the front end when they're born, and also, all my kids are now 25. It's probably time to adjust those plans. Continue to monitor any legal changes. We've been talking about the sunset of the $14 million exemption. Seeing that come up here at the end of 2025. Well, is there going to be tax law changes? Is there not going to be tax law changes? Depending on what types of trusts you might be utilizing in your estate plan. Is there any law changes in regards to how the government wants to tax those? And then also, monitoring Nebraska's laws. And I would say your attorney can help you manage that process, but continuing to make sure you're staying on top of any legal changes. Updating beneficiaries regularly. Are the individuals that you listed for power of attorney still the most appropriate today as they were when you initially did your documents? Evaluating those trustees and executors. From time to time, we'll see either, husband and wife were on the doorstep of signing the documents and one of them passes away, and now, their plan that they thought they had in place doesn't get executed. Or, a divorce happens, a remarriage happens, and documents don't get updated. So, make sure you're monitoring your documents on a consistent basis so that you don't have that happen to you. And then just, continuing to consult with your professional team. So your CPA, your financial advisor, your attorney, what law changes are coming up. Any, questionable items from your old estate plan that should be updated based on your current circumstances. So just, it's not set it on the shelf and it'll be used in 30 years. It's definitely something that should be updated every 3 to 5 years.
So now we're gonna turn over questions. We've had a few come through, so we're gonna read those off. And then we'll answer a few of these as well. So can a testamentary revocable trust go to an irrevocable trust upon death? Yes, that will happen automatically. Again, you want to make sure it's structured appropriately, but those do turn irrevocable upon your passing. If my son or daughter predeceases me and their portion goes to their children, would that be subject to GST? Generally, again, assuming that it's structured properly, and you want to make sure it's per stirpe, which is by lineage, and not pro rata, it can go down and it would not be subject to the GST in that case. And if you have questions on that, reach out to us offline.
That's kind of a specific question.
Yeah.
So I think you could structure it not to be subject, but potentially it would be. So that's pretty specific. So how is a state valued when it has land and business? So if you own a business entity, then the business would have to get a valuation done on it. So, Lutz can do a business valuation, or there's other providers that can do valuations. And then they're gonna value either the stock or the partnership unit value. The land, you'd have to get appraisals on the ground by an appraiser. So you'd have to get other advisors involved if you're trying to, or if you pass away and you hold those assets. You mentioned a trust being set up and then a divorce occurring and being aware of how something could become marital assets. Can you talk about that topic?
So I'm not sure if this was specific to the Nebraska marital or the elective share. In that case, if you don't have any trust in place and you got remarried and then divorced, they could, in theory, potentially go after half of marital assets. If you're talking about going down to your kids and then going through a divorce, generally in that instance, as long as the assets stay in trust, they could be protected and not become subject to the divorce proceedings. So it's kind of a few ways that may go. So if you wanted to reach out to us directly, we can probably answer that a little bit more in depth.
Okay, so Nebraska inheritance tax, is there a different tax rate if child resides outside Nebraska? The answer to that is no. That's just the 1%. What type of 501c organizations qualify for the 0%? I'm not sure on that. The 50% versus the full basis step up, is that good or not? So with the that question was in regards to if we have a husband and wife and they each own assets 50-50 versus one of them owns the assets outright. Is it good or not? It could be good. If it's 50-50 and one of them passes away, at least you get the basis step up on half of the assets. If it's all owned by the surviving spouse, well, now you didn't get a basis step up when the first spouse passes away. Especially if it's an asset that is going to be sold in the short term, then it probably matters because now you're paying income tax when you potentially could have not paid income tax. If it's an asset being held past the second spouse to die, maybe it doesn't matter. So it's just a case by case situation. Explain the value of using Lutz an attorney versus just going straight to an attorney. So, we like to work as a collaborative team with your other advisors because, we might have more intuitiveness about what's going on in your, your business situation or your family situation that the attorneys might not be aware of, or vice versa. Same thing with the financial advisor. So just, having everyone on the same page, I think is very beneficial to clients.
Do gifts become taxable for the kids? If you're using the annual exclusion amount, that is not taxable to the kids. The only area where taxation may come into play is if you sold an asset to give them cash, then you, as the person selling the asset originally, would have capital gains on that. Similarly, and this is something that you are able to do, if you gave your child an asset instead of cash. So again, let's say that you have a stock that you bought for $100 and it's now worth $10,000. If you gave them that stock, then the basis would carry over. So now it would look like they acquired that for $100 as well. So in that example, if they later sold it, then it would be taxable, but the gift itself is not a taxable event.
Yeah, can you put money into a trust for your kids to use later in life without being taxed? The answer is yes. So one thing to keep in mind with when you fund a trust, as long as you're underneath that 14 million, there's no gift tax on that transfer. The money that's held inside the trust, if that's generating income, so, it's in a brokerage account, you've got interest and dividend income, that's going to be taxed, whether that's at the trust level, that's at your level. If so there is tax on the income, but when that money comes out of the trust and goes to your kids, there's not what I'll call a transfer tax going from the trust to your kids. So yes, that's something that you can have in place. And I think, yeah, that's a Lutz question. I think that's it.
Well, we appreciate you joining our webinar. Again, if you have other questions that we didn't, address specifically, or you want to have them answered offline, please reach out to us. We're happy to, again, add some additional color here. But yeah, thank you again.